On this last section, I just want to highlight a little bit more on the union's duty to represent people. This is part of their role as being the exclusive bargaining agent. If we've organized a union and they've been voted in and they've been established through the proper procedures, perhaps with the NLRB, then the union now has this responsibility to represent members of the bargaining units. They have to represent them in negotiations of the contract and in the administration of that contract. The union has a legal responsibility. It is a legal responsibility to the interests of all the members, and they have to defend the contract that has been established in good faith and not act in an arbitrary nature where they treat one bargaining unit member different than another. That said, unions can use discretion in terms of how far they want to go in pursuing a grievance. Bargaining unit members can sue a union if they feel like they haven't received fair representation. And those types of cases are heard by a district court. There can be a jury trial if the employee is trying to get back pay. Now, that said, case law has also established that the burden of proof for failure for fair representation falls on the employee. And it's also been acknowledged that unions do not have to take all grievances to arbitration. And when there is a fair representation case, the courts are just looking at whether the representation has been fair, and not whether the grievance itself had merit. So it's very important that unions follow through on their obligation for fair representation, and there have been these golden rules established. So all grievances should be considered, but solely on their merits. And they should investigate grievances quickly and thoroughly. The process for addressing grievances should have time limits, and so it's very important that time limits are not missed. The process is important to have thorough written records and to communicate and keep the grievant informed. Again, we're representing the contract, not the particular grievance, so it's important that we have a very valid reason in terms of what the contract says. And in some cases, grievances do lack merit, and when they do, it's our obligation to drop it. It's an obligation that we have to all the bargaining units members that we represent, because if the grievance does not have merit, then we're just wasting their resources. Well, I'm going to wrap it up there. If you have any questions, please don't hesitate to contact me.